Well, good afternoon, everyone. I was going to say welcome to this 3CL seminar, but actually you should be welcoming me because this, by the looks of the audience, this is a private law centre takeover of 3CL today. So I'm the imposter, not you. So we're delighted to have another one of our joint Cambridge Private Law Centre 3CL seminars. This one probably a bit more for the private law people than the commercial law people, although there shouldn't really be an artificial divide between us, of course. I'm delighted to introduce Professor Dr. Alexander Schall, who is Professor of German, European and International Private and Business Law at Leuphana Law School in Nuremberg, Germany, although he's currently a visiting fellow at the Commercial Law Centre at Harrison Manchester College at the University of Oxford, where he joins us from today. Dr. Schall's main fields of research are German and international corporate law, German corporate insolvency law, German capital market law, and also European corporate insolvency law. He has a particular focus on English company law, which is remarkable for somebody who is skilled in so many other things.
I learned it before the German, that's why.
Yeah.
I learned it in my master.
I was going to say remarkable for a German, but that would be a bit racist, so I changed it at the last
minute.
Well, including the possible legal consequences of Brexit, so special reason to be interested.
Don't mention the Brexit.
So, having said all that, Dr. Schall is here to talk about private law more generally today, particularly the law of restitution. Hence, his title today, The Principle of Unjust Enrichment, a Comparative Perspective. So I'll hand over to Alexander.
Okay, thank you very much, Mark. Thank you very much for having me and for joining me and for being interested in this stuff. Actually, yes, the company law stuff you read, this comes from my second book. Whereas today I'm here for my first book, and it was probably, to become a professor in Germany, or you may know we have to write 2 books, so that's why we're a bit broad, and it makes you clever people, but it also makes you older people and takes a lot of time. But the first book I read was still the things I dare say I know best, so that's why I'm running through the world as a company lawyer, as a business lawyer, go to the commercial law center, but whenever I can, I'm doing pure private law and here as a comparison. So I hope that you're all aware, because I cannot really, I have to presuppose a lot of you. So I hope that you are aware of the English principle of unjust enrichment, of the 4-stage test of Banque Financière, which says that a restitutionary remedy in unjust enrichment will lie if there's an enrichment of the defendant that comes at the expense of the claimant, there is an unjust factor, and there are no defenses, most notably change of position or what else you have. So this is a direct right to restitution. So the principle here is not a usual legal principle like party autonomy or whatever that may explain some rules of law, but it's a direct legal rule under this 4-stage test. It aims to reverse direct shifts of value, and thank God I'm here without all the people who would doubt that already and shout. When I wrote my first book in Germany, it was the same. You cannot say one single word undisputed. So, but you have to do it, otherwise you can't say anything, although you might know better than other people who say it. But this is like, but I think you can say that jurisdiction and also people like Andy Burroughs now firmly hold that this applies to direct shifts of value, whatever that may be at that stage. Then the development that made this talk possible inspired it a lot, was the criticism by Robert Stevens, who is a former tutor and a good friend in Oxford, and when I arrived here I just had his LQR, Law Quarterly Review paper of last year, on my desk and started reading, and he is heavily criticizing this as the unjust enrichment disaster. And he makes a lot of points, and he draws a big picture, but to give you the two ones that are most important for me, because they can be compared to our discussions, is he says the law must not reverse direct shifts of value, but performances. He wants to look at performances. And he says so because if at your request I sing a song for you, nothing is transferred to you. That toys at services, even in particular with services that are not services to an end, labor, nothing is transferred to you. So no shift of value. And also he points to the so-called three-party situations like bank transfers, where the transfer might seem to go from the bank to the other bank or to the recipient, whereas the performance is obviously made by the transferor of the funds, so it points into the wrong direction. And also he says it gives the wrong solution of the stamp case. The stamp case is I owe a very precious and rare stamp, you owe it too. By mistake I destroy mine, yours doubles in value. Can I claim the unjust enrichment from you? And he says, no, there can be no claim. And he's firm on that. And so that's why he says we must look at performances and not reverse direct shifts of value. So we're still in the case for legal comparison. You may not know, unless you're from German background, that in Germany we had a very similar enrichment principle based on direct shifts of value. It was overcome in the course of similar criticism by Walter Wilburg. And makes very similar points. Services or also user is not a transfer, nothing is transferred, nothing goes from you, no title is transferred. That was the one thing, and the other thing was the three-party situations, where the Germans ended up, just before they skipped the whole thing, in searching for, what was it? Immediate enrichments by indirect performance. So it's just paradox, and Walter Wilburg was the one to say, as we say, the emperor is naked, the Kaiser is nackt. Others opened their eyes and saw the naked emperor, and we skipped the principle, and instead we applied, as Walter Wilburg demanded, you will see later, the claim to reverse performances, the Leistungskondition, and some other claim to undo restitutions for wrong. So this said, this is the similarity that calls for the legal comparison I'm going to make. The following doctrinal differences are irrelevant for present purposes. I can tell you I wanted to skip this very briefly, but this took me the longest time when I wrote the paper, because to understand whether it matters or not takes a long time. It's like if you're doing economics, all these robustness checks and so on. These are my robustness checks. Does it matter that our principle, although phrased in the same words, has a different historic basis? The Roman conditiones instead of action for money had and received under Moses MacFarlane. Does it matter that civil law unjust enrichment only gives a personal claim to the enrichment, whereas in England you can have proprietary remedies, subrogation or whatever, even trusts. Also, there's a different notion of performance. So Robert Stevens gives a definition. I don't think that English law is very heavily endowed with definitions of performances. He gives one, but it's certainly not the one that Germans would use. And to give you one example, in Germany, for example, making a gift would be seen as a performance. Whereas here, performance you do to discharge a contractual obligation. But since both in Germany and in England, most performances are related to contractual obligations, I decided this does not really matter. And also, when we don't look at a performance that the English would call that way, we still look at transfers of value, so that is just terminological. And the final thing, which was probably the most difficult thing, we have a different system of justifying the reversal of the direct shift of value, if you want to say so. This is German system lack of legal ground, or also sometimes here discussed as absence of basis, versus the English system of unjust factors. You can believe me, I've tried to see through that because it all is connected, because the unjust factors give you the reason why we reverse it, but it's similar enough. There are differences, and I can explain them if you want, but we only have, I'm in the introduction, we're almost done, so they are similar enough. This is important to know. So make it a little bit quicker now. The civilian enrichment principles, the first thing I would like to state here is there are at least two versions, one older, one new. The older one is this famous sentence of Pomponius: under natural law it is fair that nobody shall become richer from another's detriment or injustice. So the detriment is the enrichment side, from another's injustice this is restitution for wrong side. It covers even both. And it is still seen, if you look in Banque Financière, the sentence, you should not become richer from another's detriment, is still seen as the basis of English unjust enrichment too, and is called so, but we have overcome this, and we have overcome this for a particular claim that we didn't want anymore, which is here the actio de in rem verso. This is against third-party beneficiaries. I cannot even think about and dream about explaining what role it played in ancient Rome, but it was applied in the medieval times to give a claim in that case here. And you will see that Banque Financière just jumps into your mind. If A gives loan to B, who pays off mortgage to C and sells on to D, unencumbered, before becoming bankrupt and of course not repaying the loan, we can discuss claims against C and D under the version claim because they benefited somehow. And German civil law decided in the 19th century we don't have that, we don't want it. And it also gave rise to a sort of general equitable claim, the loss of someone, the gain of another one. Why not give a claim in a stamp case of I rob? It would well sit with that principle. So in the 19th century, we came up with a new principle designed by Friedrich Karl von Savigny, and this is now very similar to the one that you are applying now in England, the direct shift of value without legal ground, you would say, flawed by an unjust factor. But it looks at the direct shift of value. It was derived from the Roman Conditiones. It excluded the actio de in rem verso, and it was adopted by the codifiers, in particular by the drafter of the pre-draft of the big German book, as basis for codification of our law of unjustified enrichment. Both Savigny and Franz Philipp von Kübel and all German lawyers of the 19th century agreed, although the words were still loose at the expense, benefit, enrichment, this excluded the version claim. That was the whole idea of the direct shift of value, no indirect beneficiaries, no version claim, no claim to say in Banque Financière. And that went so far that the German legislature discussed the version claim and rejected it because it's too vague and we didn't want it at a very different place in the motives of the big German book. So it didn't even discuss it at the law of unjustified enrichment, but somewhere else, because in our mind this was gone. This was the old principle, and we had a new one. Then we have the demise of the direct shift of value for the reasons I just said. It was attacked for this paradox in three-party situations, and it was attacked that it could not explain services user and so on. Instead, there was a plea to introduce a Trennungslehre, separation theory, to apply the Leistungskondition to reverse failed performances and some restitution for wrongs. It was condoned by Ernst von Kämmerer and then accepted by the Supreme Court in the early 60s. So, internal conclusions by now, and we could maybe should then just stop. If I was not an oddball but a normal German lawyer, this would be it. Okay? I would have taken more time to explain this and that. This would be it because all the Germans think that we were right to do so. So the internal conclusion is the former Savinian enrichment principle is similar to the current English principle. It relies on direct shift of value. The notion of performance differs, I told you, but not in a relevant way for present purposes. Most performances relate to contracts, so we don't see into the details here. So the criticism by Robert Stevens is similar, apart from the stamp case. You understand why? The stamp case was already dealt with by going from old principle to new principle. So stamp case was gone. Robert Stevens cannot see this because here you didn't go from old principle to new principle. So stamp case is still there. The wording is wide enough in the new principle to give rise to a remedy in the stamp case, but we didn't discuss it. But the other 2 points were exactly the same. The demise of the shift of value in favor of performance-based claims apparently support the points of my learned friend Robert Stevens. And indeed, I agree that the enrichment claims should reverse performances, so I oblige. But the main point of this talk is, contrary to both German doctrine and Robert Stevens, I will argue that the reversal of performances does not mark the defeat, but the correct application of the direct shift of value. And this I want to convey, and after that we can discuss. Performances are direct shifts of value. Savini saw that, and I give you the quote here. Every performance is either made with money or with money's worth. That means that the simple act of giving and receiving of value makes them a direct shift of value. Okay? The equation of money and money's worth, that is what makes a performance a shift of value, and that was seen not by me, but I just rediscovered it, but by Savini 170 years ago. It's like, yesterday night I thought it's like, the 16 in chapel, the godly spark. Huh? That is a shift of value. Cain, Abel, they are the indirect enrichment. That comes later. That is only that and nothing else, and always that. So that's why you can already see why it's so misconceived to, search for direct shifts of value, of daughter, Menelao, or whatever, because it just moves away. It would do what we wanted it to do, and then you can say, well, you wanted it to do because you said that was a Roman law, and you wanted to be, but Savini didn't want to be precise on Roman law. He didn't care what 2,000 years happened. He wanted the right law for today. And that makes it interesting for the discussion here as well, because I think that the underlying notion is just the same here. Giving and taking of money or money's worth. If you look into the Companies Act, so here the company lawyer, you can pay up the capital by money or money's worth. So this equation, or instead of paying the rent, the music student plays on the piano for Christmas for the landlord. Money, money's worth equal. So this is a shift of value. And we undo that, and then the performance as such is the shift of value. But then comes the big mistake, and now you understand what only I can understand in German and no one else, because no one reads my book and listens to me. Thank God, you're friendly people and you give me asylum in Cambridge, so why not? Enrichment claims must return performances, not shifts of value. If a performance is a shift of value, it's still not right to search for the shift of value instead of the performance. And the argument is a multiple performance. So if A paints the door, as said, we can see a shift of value. Money's worth is handed over, godly spark, to the landlord. However, the same natural act could also be a performance from A to his employer, who performs as a subcontractor, from a main contractor, who performs to the customer, who is the tenant of the landlord. All of a sudden, the same act has 6 performances. Now, if you now start looking for a direct shift of value instead of the performance, you are lost. because the only shift of value you're looking for is the performance. And that's why you must look at the performance, otherwise it will derail. And that was the mistake that the Germans made. They could have seen it from the pre-drafts and from the first draft that every performance needs to be restored, and it's no good to look at something else than the performance, but they didn't. And that's why derailed it. And the multiple performances, the same is of course true in cases of actual transfer. So there was an old imperial court case, and I can't find the reference correct anymore, that there was a conveyal of land from A to B, but it delivered on 5 contracts, intermediate contracts. So A, A1, A2, and then finally, so they transferred only once, but on 5 contracts. Now if you look at the transfer of value or shift of value, you end up A to B, but you must look at the performance. And if you don't see that, you cannot apply the principle correctly. Certainly not in Germany, where we had it written, where we could see it from all the legislative materials that performances must be restored. But I think the same argument can be made to support Robert Stevens. Look at the performance, but then again I say it doesn't defeat the direct shift of value. And I give you, so failure of Savinian principle, we can chip that it's not the principle that failed, it's a misapplication. You must look at the performance, not at diverging shift of values. You could look at every performance and describe it as shift of value, but if you do that, you just make yourself ridiculous. The performance is the shift of value. So the gains, why do we have gains? Well, Rob just says performance and okay, but I think understanding performance as a shift of value has gains. First, it provides for me the normative foundation of both unjustified and your unjust enrichment. It attaches performance-based enrichment claims to performing party and recipient and excludes claims against indirect beneficiaries. It gives you a reason to do that. It gives you a reason to say bank financier is wrong unless you find another principle, but it's not unjust enrichment. And it determines, and this is important for me, and nobody believes it, but we will concentrate on that. Therefore, it determines the scope for not performance-related enrichment claims. Finally, it denies an enrichment claim in a stamp case, what not every other principle can do. So the normative foundation I took here from Stolja. I know Stolja sees unjust enrichment differently. He sees it on a property basis, but I just borrow from him this one good sentence. Things or money cannot validly pass from one person to another without the former sufficient consent. And since I equate money and money's worth, I said value here, not title, value. Value cannot validly pass without sufficient consent. That leads me to a result that unjust enrichments are shift of value impaired by lack of consent or flawed consent, 2 cases. And this is then a party autonomy explanation. I wanted to, party autonomy requires me, allows me to do what I want, to dispose with my things as I want, but then requires me to stand to it. And this is not only pacta sunt servanda and freedom of contract, it's only if I make a gift to the beggar and St. Giles or whatever, wherever they are here. I give £1 coin, I cannot come back 5 minutes later because now all of a sudden I need a token trolley and I gave my last £1 coin, so please can I have it back? So party autonomy is the commanding force in leaving dispositions, making dispositions, freedom, but then being bound to it. And party autonomy requires undoing it if the consent lacks or is flawed. So, and therefore, those people who do not directly benefit from your disposition are, in this explanation, not answerable to the flawed consent. So, the defendant in non-performance enrichment, that is even more interesting, I think, because I think that here I can do better than restitution for wrongs and also better than the German Eingriffskondition. My question is simply on what I said, would the receipt of the value in question by the defendant have required consent of the claimant under valid bargain? This is a legal judgment, I admit that, but I think that the parameters are more accurate than searching for wrongs or interferences with rights that allocate values as the Germans do. And here are my examples. If I climbed a tree on your land to watch a football match in the neighboring stadium, I trespass, but I do not take money's worth. Nobody would see that. There's no enrichment claim. But if I sneak into the room that you rented out for a coronation case, so you then take value for it. Now I take value from you, but only then. But in both cases, I trespass the land. So neither the wrong nor the idea of allocation of the gain by that right does lead me to the right result. Next thing, I'm particularly proud on that. We wanted to do it with the Sheldonian. I did it with all sorts, but then I looked up Wembley Stadium, Capital Radio. They engage the musicians. Wembley Stadium owns the venue, and Capital Radio sells the tickets. So if I sneak into that concert by claiming the fence or whatever, it is Capital Radio who should have sold the ticket to me, from whom I should have got the value, because they are the ones who sell the ticket in that setting. It's nothing to do with the interference of Wembley Stadium Company's ownership or with the interference with the intellectual property of the musicians. This all is the wrong way. The right way is I just look to the hypothetical bargain. So, nice thing to see that the old things also are still valuable in the future. I learned first of all that you can lose your bitcoins if the exchange is hacked. That you can then know where they are, but you cannot get them because you don't know who holds them, but you can at least try. But then I heard a conference 2 weeks ago that my German fellows think they don't have a claim because there's no legal right interfered with. Oh, Bitcoin is just it's a value, but is it a legal right? So they dropped the claim. Think this is persuasive? If not, I might be the better one. So finally, in the stem case, the defendant did not take value he would have had to pay for, and that is, so I can do these natural disasters. They are for me wrong. They were, by the way, accepted by the Romans, not only under the Pomponian sentence, but do away with them. There's just one case that has been given rise to a claim already in the Code Hammurabi. This is the grazing of cattle of another's land. But again, you can say, well, this is typically something you have to pay for. Huh? If the farmer comes and brings his cattle or his sheep, most probably, to your land, he has to pay for that. So, hypothetical bargain, if he doesn't do that, he is liable for the value he has taken instead of received validly under a consensual transfer. So, that was in a nutshell. Well, you will see the paper is a bit thicker. We can talk about performances, we can talk about three-party situations, but that would certainly be too much, but we can do with the question. That is my outlook. The Bitcoin the Bitcoin exchange I just mentioned. The other thing where unjust enrichment will probably become more powerful than it is now is with smart contracts, because smart contracts allow you to execute transfers without relying on binding obligations. They just do, they're programmed to do, but they relate to real life exchanges of values, and so you can never, no algorithm can prevent them from going wrong. So what you then will need is something to restitute, and this works. A law of unjust enrichment has in Roman times already provided for a mechanism. If you don't have a binding contract, let's say a confidentiality agreement, and I don't want to make too many allusions, but you know about whom I'm thinking, confidentiality agreement, not talking about the consensual intercourse we had, okay? And pay up, okay. If you now speak out, you ruin my brand and you're liable in damages. This is the way we would do it today. The Romans could not do it because they had very strict pattern of contracts they could agree, and this was not one of them. They were innominate contracts, and what they did then was, well, here's the money, you don't speak up. You were not obliged to stay silent, but if you spoke out, then you had to return the money. So this is the older mechanism that works without obligations. And it's still there. You can still have it. Failure of consideration. You have it, we have it. So if we do away with obligations, we still have this in place. And we still have unjust enrichment to put things right. And maybe, I don't know enough yet, might turn my eye to it. Maybe we will even need more unjust enrichment, and so much the more important it is to have it right and to have it easily accessible and not to have a big mess with shifts of value here and there and everywhere. So this is my claim, follow Rob Stevens, but believe me, it is a direct shift of value, every performance is, and thank you for your attention. So,
about 15 minutes or so for questions or comments.
There, yes.
What was the hardest example of a performance for you to fit into your argument that it's always a transfer of value? Because I'm trying to think of something like I hit you. I'm trying to think of the hardest thing for your thesis, and you must have thought about it a lot more than me. So I'm just. What was the hardest example for you to reconcile with your thesis?
Actually, I from a German perspective, everything can be a performance, even not doing anything. Even, for example, the exchange you have with Facebook, like you have access to the network, whereas they have access to your doings. Even this can be a performance, and even this can have money's worth. So, for me, it's still a shift of value if I undertaking not to compete, for example, because it's valuable. It may be difficult to gauge and to evaluate how valuable it is, just as in the Facebook case. How valuable is letting them see you naked? How valuable is it? But it is a value. It is a shift of value. And so I really don't think that I have any difficulties with that. I think that the hardest part for me is if I don't have a performance agreed, and then to find whether there should be one. That takes a value judgment or a legal judgment, which I must say is hard to take.
But it's not just saying that because somebody in the world somewhere might pay for anything, or for the omission to do anything,
yes.
Therefore everything is a performance.
Yes, that is the problem, because party autonomy allows you to agree on everything. Yeah. And so on the second step for the non-performance, if it's a performance, well, they have agreed. Typically they have agreed, and if it's a performance to discharge in Germany, you would not have to agree a second time, but then they have agreed to create it. So then you have a framework that says, well, this and this conduct is owed under a labor contract, under a service to an end contract, whatever, and therefore it has this and this value, which may or may not be the value the parties have put on it. But if you follow from that everything, climbing the tree, I could sell you the tree, okay? But if I don't do it, then you don't take value, and I think I would approach this by an objective taking into account of the situation, like, has this been done? Was this usually done? And if it was not, then it's not taking value. So that's why I made up this case with the coronation window. On other days, you don't sell out your window to let people look out. I have also had another thing, using trespassing to use the toilet in your outbuilding, as opposed to sneaking through the barriers on a motorway station, where you have to pay for it. So I think that we can agree that there are situations, some objective values, like riding on a train or using the toilet or something like that. I would say, if this is taken, you take value, you steal value. And in other situations, you need the agreement. So what Bill Swalling just on Friday, taking your bike for a ride. Yes, of course, you can rent a bike, but is this really, if you never rent it out, this would be a hard case for me. I admit this would be a hard case for me. There are rental bikes all over, but sometimes they don't even cost you something, just a registration. So is this a value you're taking or not? The trespassing, we don't, but still I think that this is value having value. You can steal value. I think that you can do. It need not necessarily be conferred upon you. And to cater for that, I follow this approach. And I think, by the way, that although I did not put him in yet, but Andy Burroughs now is there also with taking value, conferring or taking. But he's very small because he's there for the ignorance cases only, where this value is somehow goes from the thief to someone else, and these are the only cases more or less where he sees there's no conferral. There must be a taking of value, but for him restitution for wrongs is not unjust enrichment. For me, in these cases, it is. It is not the taking away the bribe. Read Hong Kong Attorney General, Hong Kong. That is not unjust enrichment, I agree. But there is an unjust enrichment if you dodge the fare for the train. Something that you should have been sold a value, objectively determined, that you have been sold, transferred by a valid contract, and if this is lacking, you have to restore it. Other example, which is a very, I'm also, I think, can do better than at least the Germans, is unauthorized sublease. Very often happening now with Airbnb. In France, they are very easy, no doctrinal issues, just a sort of what was a penalty damages, and so they took it all away. But that dodges the doctrinal issue. To whom does it belong? German law, under their construction, say it cannot belong to the owner, the main landlord, because he has already rented it out, and so they argue his property right doesn't allocate a second rent. That is true. I don't think that you should have everything, but if you apply for a sublease, you typically would have a higher rent. You get authorization in return for a rent increase because there's more use now being made of the rent. So there I again have my value, which is taken without the consent and which must be restored. So with my concept, I would give you that value for the higher rent that you would typically give in return for the authorization, if the authorization is not sought after but just taken de facto. And yes, so it is a difficult issue. And for example, in particular, if nobody else has thought that way, but sometimes you see the idea of the hypothetical bargain popping up. If you read Andy Burroughs, if you read some of the cases, it pops up. And I think it's the notion we need. So I don't believe in title. Yes?